On behalf of the Executive Committee of the Nigerian Bar Association, the section on legal practice, we are delighted to welcome all our special guests here present, speakers, and all the delegates who have come from far and wide all over the nation to be here in Plateau State, the home of peace and tourism, to attend the 2025 Annual Conference of the Nigerian Bar Association section on legal practice. And we have an unusual theme. The theme for this year's section is Uncommon Challenges in a Rapidly Changing Legal Environment.
Yesterday, when I was called upon to speak at a cocktail, I proudly spoke about the resilience of our lawyers who, despite the security challenges, the bad news emanating from Plateau, and the reported number of deaths, defied all odds and refused to be cowed. And they traveled long distances, some by air, some by road, just to be here to attend this conference. And then I noted proudly that our colleagues have shown that they stood with Maya Angelou when she said, "I may be changed by what happens to me, but I refuse to be reduced by it." We have refused to bow to fear, and we are here, and I congratulate all of us.
Enjoy yourselves while you are here. Make friends, network, learn a thing or two, improve your knowledge of the law, and recalibrate yourself for better practice. We are told that Jos is not only a tourism destination, but is actually a medical recommendation. So, in the words of the Attorney General, I appeal that we all enjoy ourselves here and have a wonderful conference. Welcome to Jos. Welcome to the beautiful little Plateau State.
On behalf of all NBA branches of the Plateau, I encourage our esteemed guests and delegates to explore the unique charm of our state, from its breathtaking landscapes to its rich cultural heritage. Plateau State offers a tapestry of unforgettable experience that we hope will leave a lasting impression. Once again, I welcome you, and I said, Imwale, Ankesia Chanyi, Kaja Bi Kube, Kaja, you are most welcome to the beautiful state of Plateau.
Our premium showcase session this year seeks to address separation of powers and judicial independence in a rapidly changing legal environment. Question: is Nigeria on the right course?
For the powers to be exercised by the three arms of government, Section 4 actually vests the legislative power in the National Assembly, while Section 5 vests power of the executive in the President, and Section 6 vests the judicial powers in the courts. So it baffles me when an arm of government leaves its space and comes into another space and truncates some judicial proceedings. It's really, really not encouraging. And we are here to speak to truth and to speak to power. These are the uncommon challenges that we are facing. And people will not understand the pressures on the judiciary and on the heads of courts. But rumor would just go about and everyone would be blaming the judiciary without knowing what is going on at the background.
The infrastructure of the judicial system must be paid for. Justice today requires high-tech solutions, automated courts, digital systems, public address systems, on-demand certified true copies. Who is going to pay for all these issues? How are they going to be paid for? So it's critical for the judiciary to discharge its function as the last hope of the common man and everybody else, that it must have the tools it requires to deal with its cases. Second recommendation I would like to make is that the power of the purse that the legislature hold should be administered ministerially. That is to say that the legislature do not have the power or discretion to whittle down the budget, except in extreme cases. What should happen is that the budget as presented should be granted. I have heard it on good authority that when those budgets are being defended at the National Assembly, people within that system make requests. Put differently, I'm saying that the advocacy needs to be constant and needs to be persistent in order to change cultural behavior that we currently see. I hope with these few comments that I've made that I've tried to get this point across, that financial independence of the judiciary is critical to everyone and our nation. Thank you.
Thank you, Leonard Silk.
So if we allow judges, or rather allow the legislative arm to take on the role of judges in the way they do, then I believe that they would be a threat to the doctrine of separation of power, which is the fulcrum of democracy in the first place. And that is why the judges need to continue to be bold. And those who have not been bold enough should take very firm stance by limiting the extent to which the legislative arm goes into the foray of deciding matters that are supposed to be dealt with by the judiciary.
Now, Mrs. Diane Okoko, do you believe that the implementation of the national arbitration policy will improve arbitration practice in Nigeria?
Given this picture on the one hand and saying that, look, arbitration should not be treated as a secondary dispute resolution mechanism because it really is a primary. It is an alternative to litigation. Are counsel ready to actually implement? So to answer your question, my lord, it's one thing to have a beautiful piece of legislation, if you can call it that. It's another to have the attitude of the users of that particular document to be in tune with the spirit of the document. So if you had, for instance, the judges who do not want to comply with the spirit of the policy, and you had counsel who will use all manner of guerrilla tactics to ensure that they frustrate not only the success of the arbitration, but that also of the policy, then we're back to square one, regardless of whether we had the NAP or not, my lord. So if for challenges, my lord, what I foresee is this is something that will really improve not only jurisprudence, our landscape arbitration-wise, but our attitude as users is going to be key to the implementation. Thank you, my lord.
I agree with you that you said the court arbitration are pro-arbitration, but some are not. And until we have those judges that are not, they do not deal with arbitration matters. So we need to have specialized courts. Mine is a contribution as opposed to a question. And I think until we do that, we'll continue to get into these pitfalls where we just have delays upon delays. And at the end of the day, I as an arbitrator and counsel and the user, they're deterred and they get an injunction stopping you from continuing. And then there's appeal upon appeal. And these layers of appeals are actually unacceptable. Dispute resolution, ADR, arbitration is supposed to be fast, speedy. And that's why commercial people come to us, because they want their dispute resolved speedily. Especially when they're foreign clients. What signal are we sending to foreigners that there's delay? And those delays are really, honestly, the things that could be avoided. So that's just where mine is a practical contribution. Thank you very much.
KYC, know your client. In 2025, we cannot afford to say, oh, we don't know, we didn't quite know who he was, we don't quite know where he lived, we don't quite know the source of his money. We can't get away with that. If I happen to be representing the governor of whatever state in Nigeria, River State, okay, let's go home. The governor is my client, not River State. If you pay me from the River State Treasury, I will send your money back. because you are bringing a problem that I will face tomorrow in my career as a lawyer. These agencies will not say anything at that time. 2-3 years down the line, they'll bring that evidence before you. And then they'll attempt to use it to force you to compromise on another client. In England and Wales, when I was practicing where it was more developed, yes, I had suspicious transactions. Because you would look at somebody is buying a property of £1 million, and his profile clearly shows he doesn't have that income. And you're dealing with the conveyancing. We are regulated by the SRA, like Nankunda said. SRA does not have the ability to investigate criminal activities, and wisely leaves that with the SFU, which is a serious fraud unit, Scotland Yard, and other agencies like that. So, whistleblower is permitted. There is a transaction at so-and-so law firm that is suspicious. Please investigate.
Let us remember that behind every legal challenge is a human story, a community concern, and an opportunity to strengthen the fabric of justice in our society.